Hi, my name is Deborah Anker, and I am a clinical professor of law and director of the Immigration and Refugee Clinical Program here at Harvard Law School. And we teach students. We represent asylees, basically, people applying for asylum, as well as other immigrants. And we do a lot of teaching and a lot of scholarship. I have a book on U.S. asylum law, which actually is very international at this point. And I'm going to mention a few cases as we're going along in my presentation, and those will be, I'll put those all on our webpage, which is harvardimmigrationclinic.org, www.harvardimmigrationclinic.org, and I will put something referring to this series, and I'll put some of the sites to the cases and stuff on there, but you'll hear them anyway. At any rate, so membership in a particular social group is one of the grounds upon which someone can base their asylum claim. And a person may be a refugee if he or she has suffered past persecution or has a well-founded fear of future persecution on account of his or her membership in a particular social group. The particular social group, known as, and I'll refer to from here on in as PSG ground, must be understood in the context of the other grounds and the anti-discrimination principles that underlie the refugee definition. As will be discussed, the best and most universal and coherent and functional definition of PSG actually can be found in the U.S.'s Board of Immigration Appeals decision, Matter of Acosta, which is 19 INN Decision 211. And that decision and its analysis has been adopted internationally. It was adopted by the Canadians in a classic refugee case, Canada versus Ward, and it has been adopted by the UK and Islam and Shah. It has been adopted by the New Zealand authorities and many others, as well as by the UNHCR, at least in part. We'll talk about this. A particular social group is defined in Acosta by an immutable, unchangeable characteristic or past or present voluntary association entered into for reasons protected by basic human rights principles that are considered fundamental to human dignity. Internationally, this framework is referred to as the protected characteristic approach. Refugee law seeks to protect those persons who are fundamentally marginalized within their societies because of characteristics that are protected as basic rights or characteristics over which they have no control. The international and U.S. tribunals and courts, as well as various commentators, have at different times and to different degrees recognized PSGs based on, among other characteristics, families, gender, sexual identity or orientation, former gang membership or opposition to gangs, childhood, past experiences, social status, mental or physical health disabilities, and HIV/AIDS, and I discuss each of these in my book. As we will discuss, Acosta's formulation has been understood and adopted by many authorities, but it's also been undermined, at least in U.S. jurisprudence. And though recently, I would say at least in U.S. jurisprudence recently, there's been a return to its fundamental authenticity, the fundamental authenticity of its approach, and I'll be talking about all of this. As the board explained in Matter of Acosta, the other four grounds, political opinion, religion, race, and nationality, can be understood as specific applications of the immutable characteristics, fundamental beliefs paradigm, PSG paradigm. The board arrived at this conclusion by applying the principle in U.S. law called e justum generis, which is a principle of statutory construction, and it literally means, the Latin translation literally means of the same kind. General words in a statute, the statutory rule is that general words in a statute should be construed consistently with specific words. And this is a quote from Acosta. The other grounds of persecution listed in association with membership in a particular social group describe persecution aimed at an immutable characteristic or a characteristic that either is beyond the power of an individual to change or so fundamental to individual identity or conscience that it ought not to be required to be changed. Applying the doctrine of adjustum generis, we interpret the phrase persecution on account of membership in a particular social group to mean persecution that is directed toward an individual who is a member of a group of persons, all of whom share a common immutable characteristic. In this sense, PSG is the most basic and foundational of all the grounds. As noted, all the grounds represent basic civil and political rights and statuses defined by immutable characteristics or protected beliefs and associations which mark an individual as outside the national community. In key respects, the other grounds are specific applications of the criteria for designating a PSG." End quote. So that's all from our Board of Immigration Appeals. Now, unfortunately, there's been, despite this unusual clarity of analysis in refugee law, we have very few examples, and this is one of them. But despite the clarity of the board's analysis in Acosta and the way in which it was adopted by so many different bodies internationally, there's been confusion due to, in significant part, to a lack of understanding of the refugee definitions, other limiting elements, and to concerns that because it isn't specifically defined in the Refugee Convention drafting records, the PSG ground might be excessively open-ended and encompass broad, vaguely defined groups. And practitioners have often also are to blame and have often presented convoluted and circular PSGs purportedly to address these concerns and perceived difficulties in establishing the nexus elements. Properly understood, the PSG ground is defined by an immutable or protected characteristic that is like but not synonymous with the other grounds, or the ground itself becomes a statutory redundancy. Membership in a particular social group has an independent meaning and should provide a sufficient basis for asylum. So, for example, there's a case, one example of these convoluted social groups that really make no sense and don't follow the principled path of Acosta. But again, with all due respect, I blame this as much on practitioners, or maybe not as much, but on practitioners, not just decision makers. So in this one case, Rejba versus Gonzalez, I'll give you a site on our webpage. The social group was decided, was defined as, and was rejected as young or those who appear to be, quote, young or those who appear to be young, attractive Albanian women were forced into prostitution. The social group there is circularly defined. It's too long. If it's that long, it's not a good social group. Just as an easy way of thinking about it. It defines this. It defines the group in terms of the persecution, and it's circular in that way, and it's been rejected on that basis. Another example is matter of in U.S. law, and I'm giving you examples from U.S. law. Is matter of Kisinga, which is 211 INN decision 357. That's a BIA decision in 1996. Now, this is an interesting example because Kisinga is seen as, and is in many respects, a landmark in recognition of gender claims. It involved a woman fleeing female genital mutilation. But unfortunately, because of the way the PSG was formulated, the development of gender asylum was thwarted in key ways, even though the board had designated sex as its first quintessential immigration immutable characteristic. So this is how the this is how the social group is defined. Quote, young women of the Chamba Kinsuntu tribe who are, if not had FGM as practiced by the tribe, and who oppose the practice. Now, how I would analyze what's problematic about this this particular social group is that I think it should be women, and if we had somehow recognized sex or gender as the defining element of the social group from the beginning of gender asylum, we might have gotten off to a different foot. But it's not gender. It's much more complicated. I don't know why it has to be women who have not had FGM. That seems to me to go to well-founded fear. And who oppose the practice. And this is what's most concerning in many respects to me, and was to many of the many federal courts, who weren't, who didn't embrace Kasinga as much as they could have, had this not been there, but who opposed the practice. That's opposing the practice is a political opinion. So why is it a requirement to be a social group that you have that the applicant have an oppositional political opinion? You shouldn't have to make out a case of political opinion in order to make out a case of particular social group. They're two distinct elements, and yeah, they're two distinct elements. And again, you know, these are floodgate concerns. You know, there'll be so many of these. God, the world is full of abused women, which it is full of abused women. But being an abused woman, or coming from a country which abuses women, I'm sorry, does not make you a refugee. First of all, many people don't make it to the West, as we've seen in dramatic form recently. And other criteria in the refugee definition, play this filtering function. Well-founded fear. Does the person have a well-founded fear of persecution because she's a woman? Does the abuse or whatever harm she's been subjected to or fears being subjected to, does it rise to the level of persecution? The membership, we shouldn't have the whole theory of the case and the membership in a particular social group ground. I'll skip some of this, which I had I think I've pretty much dealt with, and I don't want to go on for too long, but that's the basic definition from Acosta and from the Ward decision as well. This has been a big problem with the PSG ground. But the other big problem with the PSG ground is this immutability or protected characteristic formula from Acosta is not the only one that has been put forth. And the Australians put forth a social perception formulation. And this is from one of their applicant A, one of the classic cases defining it. A group is a collection of persons. The word social is of wide import. It must be cognizable as a group in society, and that its members share something which unites them and sets them apart from society at large. Now, as some leading refugee scholars, Jim Hathaway and Michelle Foster have noted, the difficulty with this, and many others, I should say, have noted, the difficulty with this formulation is that the first criteria is arguably unnecessary, since unless the group is identifiable in some way, the potential for there to be a risk of being persecuted for reasons of membership in the group is non-existent, while the second criteria merely affirms what the group is not. Hence, the only meaningful criteria in the third, the notion that the group must be distinguished from society at large. But this is confusing and messy. I mean, how is a decision maker going to determine whether the relevant group is distinguished from society at large? It was initially assumed that the social perception test requires that the home country perceive the relevant group as a particular social group. However, the Australian court went on to emphasize that perceptions held by the community may amount to evidence that a social group is a cognizable group within the community. It's usually compelling, but it's not absolutely necessary. Again, this analysis taken from Hathaway and Foster. It's not clear whether the group has to be subjectively perceived as a group rather than merely objectively cognizable or set apart in order to constitute a particular social group for convention purposes. And you can see how much, well, to me it seems very obvious, how much less depth, how much less theoretical integrity and analytical integrity, both in terms of U.S. statutory interpretation, principles like Justum Generis and Vienna Convention, principles for interpreting treaties, looking at the context and the purpose, how much weaker this is compared to the protected characteristic formula. So, and I have to say in the U.S., not that this is an international forum we're having here, so I don't have to go on about the U.S. for so long, but this really threw the U.S. Off guard and sent the jurisprudence off in strange directions, so that all of a sudden, in addition to ACUSTA, the board said, well, in addition to ACUSTA, we're also going to require social visibility. For a long time, the board was considering, which sort of derived from the social perception test, for a long time the board was considering social visibility to be literal ocular visibility. They got mocked by some federal courts for doing this, but they hung on to it for a long time. They moved from social visibility to social distinction, but the social distinction test had a lot of the same problems that the social perception test generally did, the Australian model. Now, what happened was that at the meetings commemorating the 50th anniversary of the 51 convention, I participated in one on membership in a particular social group. The board had papers from some academics who said the Australian social perception test was endorsing that test, and of course the protected characteristic test had been around for a long time. So the board tried to be Solomon and divide the baby in half and say, well, you can meet the requirements of a membership in a particular social group either by being meeting the social perception test or the protected characteristic test, or I think it was in the reverse order. Of course, partly because states don't have to obey the UNHCRs, they do treaty bodies, this got twisted. As I mentioned, it got twisted in the U.S. so that it became ACUSTA plus social visibility / social distinction, and we also added a particularity requirement. And this just, for almost 10 years, completely sent the jurisprudence into chaos. The qualification directives at the EU did the same thing. They turned an "or" from the UNHCR instructions into an "and." So that created some real some real problems, and of course the UNHCR was just being ignored. Recently, and I'm sort of tying up here, I should say there was a major case that was decided, which I'll talk about in a minute, a major victory case for those of us advocating for a principled analysis and interpretation of the refugee definition and a recognition of gender persecution. But even before that, there were signs that the board, in a couple of decisions, the decision where it changed the social ocularity requirement to a social distinction requirement, where the board was sort of re-embracing Acosta, even though it wasn't saying that it was Acosta only. There were signs that it was re-embracing Acosta, and that there was confusion and struggle going on at the board. So in August of 2014, just a few months ago, the board came out with a decision, matter of ARCG, which is 26 INN Decision 388. And in this decision, which we had written along with others, 2 amicus briefs on behalf of the American Immigration Lawyers Association. We had been representing clients. We had been winning a lot of cases on this basis. Some people have been losing a lot of cases on this basis, but there were a number of wins. But the climate in the immigration court was changing. This was on the issue of domestic violence and whether domestic violence could be the basis of an asylum claim. And in ARCG, the board said that domestic violence could be the basis of an asylum, claim. And it was just a tremendous, and this is in a precedent decision. This was a tremendous victory. Now, the group wasn't defined by gender per se, which is what we, UNHCR, everybody else had been arguing, but the social group was defined as married women who cannot leave their relationship. Now, for various reasons, that's not perfect, but it's not bad either in terms of the immutability of those characteristics. And the board said in that decision, with reference to the Acosta part of the definition, which, remember, Acosta now has been overlaid with also social distinction and particularity. But as far as the Acosta part of the formula, the board said that gender per se can constitute an immutable characteristic. Now, of course, it had said this back in 1985 with the original Acosta decision, but to have it affirmed in this way, I think, was of tremendous significance. And there was really light evidentiary requirements, I believe, imposed to meet the social distinction part of the test. So I'm going to wrap up. I'm way over time, but what are the lessons? For practitioners and I think for adjudicators, PSG should be simple. They should be basic. They should be based on an immutable characteristic. You don't have to say the whole theory of your case in the social group definition. That's really incorrect. Remember the other grounds and use them. Social group is not the only ground in the refugee definition, obviously. And if I can find this, this has come up, I think, a lot in our cases here in the U.S., which involve, most recently, a lot of cases have involved people fleeing these transnational quasi-state gangs in Central America, although they haven't been described that way in the media and by many politicians. That's what, in fact, they are. And, opposition to the gangs can be the basis for a political opinion claim. Refusing to be extorted by the gangs can be a basis for an imputed political opinion claim. and other examples. And imputed political opinion is a long accepted theory, I think, internationally and certainly in the U.S. So I really urge people to be thinking more about political opinion. I think political opinion is a very neglected ground, and not have membership in a particular social group have to play the role of being the ground for every new case that comes along, or every new type of case that comes along. But it's a really important ground. So anyway, thank you so much. I'm sorry for rambling on and on and on, and I'm very grateful to the Refugee Observatory for letting me have this chance to speak. Thank you very much. Bye-bye.